name is Katie, and what I'd like to talk to you today is when a traffic matter can actually become a felony. So a lot of times traffic matters are infractions or misdemeanors, so they're relatively small issues. But there are situations in where it can become a felony, and there's a slightly different court procedure for that, so it matters both in the range of punishment and how your case is going to proceed. So some common examples of when a traffic matter can become a felony are a DWI, for example. Your first offense for a DWI is a Class B misdemeanor. The second offense is a Class A misdemeanor, and your third offense can be a Class D felony, and it goes up and up from there. So if there are priors, the prosecuting attorney may charge it as a felony. Now, there are some requirements for the prosecuting attorney to be able to do that. For example, those prior offenses all have to be within the last 10 years. So if you have one in 1976 and you get another one, that's not going to be quite sufficient. The next thing to know is that you have to have had an attorney or waived the right to an attorney in writing. And there has to be an actual finding of guilt. Now, where this can get a little tricky for people is even if someone was given an SIS, the suspended imposition of sentence that we've talked about before, there still is a finding of guilt. So a prosecuting attorney, even though you've been advised that you don't really have a conviction, can use that finding of guilt to upcharge the offense. So you could end up with a higher misdemeanor or even a felony charge. It's important to understand how we get there, and then we can start to talk about felony court. If you have questions about this, give us a call today. We'd be happy to talk to you in further detail on the specifics of your case.